The POPI Act refers to the Protection of Personal Information Act, number 4 of 2013. This act was already signed into law on 19 November 2013, but the regulations to the act was actually only published by mid-December last year. The background of the POPI Act can be found in the reliance that we place on technology and information these days. It's absolutely paramount. Therefore, personal information has become quite valuable, with the effect that the right to privacy is at risk of being infringed upon. Therefore, the POPI Act has its objective of protecting the processing of personal information by both private bodies and public bodies which would of course include government. This is also then very much in line with international trends in terms of data privacy legislation. Every person that processes information is responsible under the POPI Act. Therefore, they would have to comply with the 8 processing conditions as imposed by the POPI Act. Essential to this is having a legitimate reason for processing the information. That can be found, for instance, in having the consent of the data subject, or having to perform or conclude a contract to which the data subject is a party. It is also then essential to have proper safeguards to prevent a breach of this information. The term personal information has a very wide definition in terms of the POPI Act. It also includes something that's called special personal information, which would relate to, for instance, information of minors. It's also important to note that information can relate to any identifiable living natural person or an existing heuristic person. That last point then being particularly to South African law. You wouldn't find heuristic persons having protection in terms of data privacy legislation, for instance in the EU or elsewhere around the globe. Any person can report a breach to the Information Regulator in the event of a breach of personal information, not just the data subject. There is also an obligation on the organization to report a breach of personal information to the Information Regulator and the data subject. The Information Regulator or the data subject could sue the responsible party for damages, irrespective of whether negligence or intent is found with the responsible party. Therefore, it's a claim based on so-called strict liability. The Act also imposes certain criminal sanctions and administrative fines in the event that the responsible party is found guilty of an offence in terms of the Act.